viewers and listeners. We are very, very grateful that you've all joined this morning. Today's topic is really relevant. It's in relation to children and sometimes even adults who are your child or adult relative. So we are going to show you how possible these children can come and join you, and also how to make a successful application. Now, the immigration rules is quite complex when it comes to children. So we've got an FM route, which became part of our laws on the 9th of July 2012. And then we've got a main immigration rules, HC 395, paragraph 297. 301 is gone, it doesn't work anymore. So the limited leave under the 301s since the 9th of July 2012, you cannot make an application under the 301s. But you can make application under the 297s and the 298s and the 310, which is for adoption, 309, which is also for adoption, and also 319X, which is usually for people who are here on humanitarian grounds or refugee status. The law itself is very, very clear. So if you take Appendix FM, if somebody is here as a parent and the person has a child in Ghana or outside the UK, the person can bring the child, whether they have indefinite leave or not. You can still bring your child. So if you have indefinite leave, then you can bring your child anytime. If you have limited leave to remain under Appendix FM, then your limited leave will allow you to bring your child if the limited leave was acquired either as a partner to a person who is present and settled, or as a parent of a child here. So there are two categories of people who can still bring children here, although they do not have indefinite leave to remain. So this would be a parent who is married to a person who's present and settled, and therefore has 2.5 years, either under the 10-year route or under the 5-year route. Or you are a parent and you're relying on your British child here, a child who has indefinite leave here, or a child who's lived here for 7 years. On the 10-year route or on the 5-year route, you can still bring your child. So these are the basic requirements. Now, as a child, the law clearly says that the child must be under 18 years old. The child must not be living an independent life, and he shouldn't have formed his own family. And again, that child should not have been married. So if you have limited leave to remain either as a wife or a husband, or you're relying on your child here, you can still bring your children from outside. But the child should be under 18, should not be living an independent life, should not have formed his own family, and that he should not be married. Now, if you're here and you want to bring your child, there are 4 or maybe 5 scenarios. So the first scenario is if both parents are here. So if both parents are here, you can just bring the child. The requirements will then be the suitability requirement and also the financial requirement. If you're married and under the 5-year route, then it has to be the 18.6 plus the 3.8, so 22.4. If you're on the 10-year route, indeed, maintenance is a requirement, but it's not the 18.6 plus the 3.8. It will now be the maintenance requirement that you are able to support your child adequately without recourse to public funds. The other scenario is that both parents are not here. So just one parent is here, but the other parent is applying to come. So you can still bring your child with you. Or one parent is here, the other parent is outside the UK, but the parent here has exercised sole responsibility. By sole responsibility, the definition which is given to us by the case of T.D. Yemen in relation to 297 IE is purely that you have exercised parental control over the child over a significant period of time. But the case of Namu versus Secretary of State, the Court of Appeal said significant number of times really does not mean a long time. In that case, a mother who is exercised her responsibility for only 3 months was able to bring the child here, although the IDI says that you should have exercised a parental responsibility for a significant number of years. The other factor is that if one parent is here and the other parent is deceased, then again you can bring the child. There's no issue of sole responsibility. Sole responsibility is a very complex area of law, and I will define it properly when I come to the next topic. So if one parent is here and the other parent is deceased, again, you can just bring your child. If the child is under 18, you've got a means to support the child is not married and not leading an independent life or hasn't formed his own family. And the other final one is that one parent is here, the other parent is not here. Either you can't find the other parent, or that the parent is there but hasn't got really nothing to do with the child outside the UK. But the child, you can show that the child is experiencing a serious and compelling family or other circumstance. So it's no longer sole responsibility. It is that the child, if he's not allowed to come here, will continue to experience serious and compelling family and other circumstances. Now, there's a definition of what is serious and compelling and family and other circumstances. Basically, what it means is that although you haven't had sole responsibility, but there's something, the circumstance of the child is so dire that if the child is not allowed to come, then the situation may deteriorate. What situation may cause that? Where the child is facing abuse, the child maybe has learning difficulties, and the relevant adult is not able to exercise control and care, or maybe the relevant adult is deceased, maybe the grandmother has just passed away, or the grandmother is infirm because of age or illness, or some particular circumstances happen in the child's life. Now, can I explain that you just don't say that my child is experiencing serious and compelling family and other circumstances? You have to show the evidence. So if you cannot show the sole responsibility and you want to rely on the definition of the serious and compelling family and other circumstances, I would advise you to get a report from the social services in Ghana, and also get a report from the child's school. So the child's school will be seeing the child on a daily basis during term time. And then the social service or the social worker or the social welfare officer will prepare a report to say exactly what a child is going through. And then the school can also write a report to say exactly what a child is going through and the effect of the child's circumstances on the child. So for example, if they are living in a very bad accommodation or there's no parental care and control, although you don't have sole responsibility, you can show that that particular circumstances may cause the child's welfare to deteriorate. And in addition, Section 55 of the 2009 Borders and Immigration Act also places a duty on the Secretary of State and indeed the UK to make sure that the welfare of every child is weighed when it comes to any decision. It includes decisions from children who are making applications to join their parents here. And therefore, if you can have all this evidence, including the telephone calls to the child, evidence that you speak to the school and the teachers, evidence that you send money to the child, evidence that you yourself travel regularly to see the child, and evidence that you have taken interest in the child's life, including their religious and emotional development. and how they make friends and their health, and that you've taken all these decisions, although you're not there physically taking decisions. You have delegated, and you can exhibit this with evidence. 𝗦𝗫𝗍, so you can bring your child here, whether or not you have indefinite leave. So even if you have 2.5 years, you can still bring your child. Now, if the child is old and is above 18, or this person is your nephew, your niece, you are still allowed to bring the child under the 297s. Clearly, you need to show that the child's circumstance usually will be health or medical situation is so dire that a person has to come. So I just want people to understand that you don't only have to have indefinite leave to bring your child. You don't only have to have both parents here to bring your child. You don't only have to show sole responsibility to bring your child. If you don't have sole responsibility, maybe the other parent is even looking after the child, but you can show serious and compelling family and other circumstances, which makes the child's refusal of the child's application undesirable. This could be a factor that may allow the child to join you in the UK.